Our next case on the docket is case number 22-130, Orlando Harris and, is it Blancha Harris? Am I saying that correctly?
Yes, sir.
Okay, Blancha Harris versus Bob Steele Chevrolet, Inc. Counsel, whenever you're ready. You're all right with 5 minutes rebuttal?
5 minutes rebuttal, Your Honor.
Apparently that's a fluid time anyway, so let's go.
May it please the court. My name is Brian Lee. I am representing the Harrises in this case, and as I said, I'd like to reserve 5 minutes for rebuttal. This case comes to the court from a summary judgment that was entered for the defendant in that case, and Bob Steele, and the issue in the trial court as well as the appeals court was whether this comes under the Graves Amendment, whether it's a rental or a lease.
And that's the only issue under the Graves. I mean, there's no dispute that there was no criminal wrongdoing or negligence, active negligence on the part of Bob Graves, or that they're the owner of the vehicle, or that they do lease vehicles.
True, Your Honor. There was evidence.
Whether this was a lease agreement or not, to fall under that is what the whole dispute is, below and here.
Right. And I think what's happened, as you've seen, is that that's also morphed into a consideration argument, too. And the reason I say that is because the sequence of events with the Romero case, which this court decided, was, as the court I'm sure knows, the trial court granted summary judgment based upon the Collins case, found that there was an agreement under that, and found that Graves Amendment did apply.
Well, let me, absent Romero having come out, let's say Judge Wozniak never wrote that opinion. Trial judge was bound by Collins under Pardo, right?
He was at that time. He was bound by, because there was no other district court of opinion.
Right. And Collins is not helpful to your position.
Certainly not.
Okay.
And Collins, what I would say about Collins, which I think was said below as well, is that in Collins there was never a argument that was made which was below, meaning that in Collins it was essentially agreed to that there was this transaction to happen, that there was consideration for that.
We distinguish Collins and Romero, saying Collins' opinion makes no mention of consideration, so they presume that consideration was conceded.
That is true.
That's how the panel, Cohen and Harris and Judge Wozniak, looked at it back when last year, literally almost to the date last year.
It is. And I think I was going to go to Romero because I think the court's summation is helpful when we're looking at this. So the summation was...
So that's the basis why you think we should reverse.
Obviously.
There you go.
So it says a transaction involving the provision of a complementary loan or vehicle is not a rental or lease transaction where, a couple things, no money or other consideration is identified, where the purported lessee was not made aware he was entering into a lease, and where there is no indicia of a lease agreement, oral and written. Now, there are certain things in this case that obviously are different than Romero.
Present case.
The present case, yes. There is an agreement. There was a vehicle use agreement.
Before we get into that,
yes, Your Honor.
You can't just go to this dealer and get a car for a few days unless you're bringing in a car for repairs. Would that be a fair statement?
Actually,
or is it? Maybe not.
I don't think that is a fair statement, and you're presupposing my next thing. One of the issues in this case, and when you're looking at the body of the law, is whether or not the dealership can show evidence that it only provides these types of vehicles to service customers. Meaning that is there evidence in the record that says, you know what, the only reason we give these kinds of vehicles out to the public is for them to bring their vehicle in for service. What is missing in this case is exactly that.
All right, so there's no record evidence either way, whether you could, someone off the street could come in and say, can I get a loaner car?
Correct. And I think it even goes further, because if you look at the affidavit that was filed by Bob Steele, it obviously talks about, well, this was a rental agreement, and, you know, we put in things for services and as part of the service. But what it says is that vehicles, what they call rental vehicles, are provided to customers, and it says, and prospective customers. And so in this particular case, even the evidence from Bob Steele themselves says that we're not just providing these to customers. We're providing these vehicles to prospective customers as well, people who haven't even come to us for a service. And so I think that is a key distinction that I believe brings this into Romero.
Do you think that means Judge Evander could walk into Bob Steele Chevrolet and just rent a vehicle, saying, I got nothing wrong with my vehicle, but I'd like to drive one of yours. Can you loan it? Can you rent it to me for a while and see how it goes?
I don't know. And frankly, because that wasn't part of the record, and it was Bob Steele's, because it's their defense, it's their burden of proof to show that. They have to show that to the trial judge. They didn't do it, and the trial judge overlooked it. I don't think this court should, because there are situations, as this court is probably aware, that a person can come into a dealership and says, you know what, I think I like that Tahoe over there. And I just want to take a test drive of it. I want to bring it home, see how I like it. There's no agreement to do that. You haven't signed a sale agreement. But the dealership says, you know what, I'm going to let you have the vehicle, bring it back to us tomorrow, tell you how it feels. That happens very often in dealerships. So we're dealing in a situation here where Bob Steele not only doesn't affirmatively come out and say, we never do this, they actually say they do in their affidavit. And so I think that becomes something that fits exactly into Romero. Because Romero talks about not just that you didn't know you were getting into a rental or lease, and there is evidence back and forth about that in this case. There is the evidence of the person who had the vehicle that said, I didn't pay anything, I didn't think there was a lease at all. But there's also evidence of the lease itself. The rental agreement, the vehicle use agreement, that says rental in it. But it doesn't have any charges in it. There is no evidence of any charges being filed or even charged to the person.
Does it have to?
I'm sorry.
Certainly the federal court, the 11th Circuit, doesn't think much of that argument.
They didn't, Judge, and I
You're
think...
acutely aware of that, aren't you?
I'm keenly aware of that, but I think that I think Judge Evander's question is absolutely pertinent, because in the Thayer case, they made it a point to say the defendant testified. In that case, it was Randy Marion, I believe. The defendant testified that it would not allow use of a loaner vehicle unless there was a service of that customer's vehicle. That was the evidence in Thayer. The district court, federal district court, pointed to that evidence and said, you're not doing this for anybody else except for service, and therefore me, as the district judge, I'm finding that that's consideration. The 11th Circuit looked back at that and said, we agree. That was and it was specifically called out in the opinion about that. We have a situation in this case where that is not there. And therefore, I believe that this does not fall into Thayer, where that is a critical component of what they're doing.
So if your opposing counsel goes back to Bob Steele and say you need to take out that or prospective customers, then that's another wobble in your position here today, right?
Well, one of the things, and actually, we were talking about this.
Okay.
No. I'm going to give you a little bit of inside baseball here, Judge. We were talking about this beforehand, and one of the things that we've both learned in these types of cases with the Graves Amendment is that all the things that we're talking about here as to what the Graves Amendment was before, not the case now, because Florida has actually done a statute that talks specifically about these complementary loaner vehicles. So all the things that we talk about with the Graves Amendment that was present then, we have a Florida statute now that deals with that. And so it's a little, your question hearkened me to that, because if Bob Steele did that today, they wouldn't have this issue because of what Florida law says. Back then, it wasn't there. And that's what Romero talked about too. So we believe that, again, Romero talks about Collins as well, as Chief Judge Lambert, you said. And Collins was distinguishable because it made no mention of consideration. They didn't address it. They didn't challenge it. But one part of the Romero decision I want to call out right at the end says, because there was no meeting in the minds between Fields and Mr. Abiola as to a lease agreement for the use of the complementary loaner vehicle, and the evidence instead established a gratuitous bailment, we concluded that the trial judge committed error. In this case, we have much of the same things. We have a material dispute, a genuine dispute of fact as to whether or not there was even a lease or rental agreement.
Except this agreement says it's a bailment for mutual consideration.
Correct. And
So it's not gratuitous bailment.
it's not a gratuitous, meaning from the words of there, but there is nothing in the agreement that talks about the consideration. There is no,
All kinds of stuff in there that talks about consideration.
it says the words, but it doesn't say actually, the consideration that the court, that not just Romero, but with Thayer talks about, is the consideration that this is being done because of the servicing, and the servicing only.
If we start with the fact that there's this agreement, what record evidence is there that suggests that that agreement is a sham or is not an accurate representation of the true transaction? In other words, what's on the other side of it? They're relying on that agreement. They're saying,
Here's the agreement.
appellate court, here's the agreement, the parties are bound by it. In making your decision, you should feel bound by it unless there's evidence to the contrary. So is there evidence to the contrary? And if so, what evidence?
There's evidence from the person who actually, I guess, initialed it. There was initials on it, of the agreement, but that person said, it was, number one, never charged for anything. Number two, didn't, in my mind, it was ever a rental or lease agreement. It was just something that was free. It was a complimentary thing that I got. And so the person that was part of the agreement, at least if you look at the initials, is saying that this was not a rental agreement. It wasn't a lease
But
agreement.
this person did get their car serviced.
Yes, there was a servicing of the car.
So I'm trying to figure out, like, when you go to a hotel that has a gym in it, you pay $150 a night or whatever, and they tell you can use the gym. If you don't use the gym, it's $150. If you do use the gym, it's $150. So is getting the loaner car, is it the opportunity to get a loaner car or gratuitous loaner car, whatever you want to call it, or is it the actual use of the vehicle? Are we supposed to analyze the use of the vehicle or the opportunity to use the vehicle? And if it's the opportunity, why wouldn't that be viewed as part of the consideration?
I think that when you have a situation where it's undisputed there's no charges for the vehicle.
But there's a charge for the car.
There's a charge for the servicing of it. And I think that the evidence that is missing from that is, because it's kind of assumed, I believe, by the appellee that, well, the only reason we gave them this car is because they're servicing the vehicle. That is not an assumption that they can make because there's no evidence backing that up. And so that's what I'm saying regarding that issue is that, and again, I think all of you realize is that when we're talking about the Graves Amendment summary judgment, it was on their affirmative defense. They had to prove by the evidence, under whatever summary judgment standard we're under. At that time, I think we were under the new standard, which we've briefed. But they still had to present that evidence. They did not. And in fact, the evidence that they did present said something exactly opposite. And so we believe that for that reason alone, the trial court's granting of the summary judgment was error. I think I'm going to reserve the rest of my time, if I can, Judge Lambert, for rebuttal.
No problem.
Thank you so much.
Thank you, counsel.
Good morning. May it please the court. Jamie Bellotti Moses from Holland & Knight in Orlando on behalf of Bob Steele Chevrolet. I believe that we've gone a little astray as to the issues. At first, Judge Lambert, I believe, asked right away, isn't the only issue here whether there's a rental or lease agreement? And I believe that is the only issue.
Well, I didn't lead you astray on that.
No, we've gone astray with the
Oh, the rest of you are
subsequent
going
questions.
astray. I was not the astrayer.
You were not the astrayer, sir. You're starting off the new year fabulously. But the issue is just whether there is a rental or lease agreement. And in Romero, a panel of this court said that, in sum, a transaction involving the provision of a complementary loaner vehicle is not a rental or lease transaction where no money or other consideration is identified by the parties at the time of the transaction, where the purported lessee was not made aware he was entering into a lease, or where there's no indicia of a lease agreement. We have that with the vehicle use agreement. And we have it all over the vehicle use agreement. She initialed the agreement under the insurance requirements for renting a car. She initialed the lease agreement under the criminal penalties for not returning a rented vehicle. It defines a rental period. It defines the vehicle as a substitute for your auto that's being replaced. It states it's a bailment for mutual consideration, and counsel was actually incorrect. The policy specifically defines what the consideration is. And consideration is defined as, and I'll read it exactly, by signing the face page, you agree to all terms and conditions of this agreement and acknowledge that binding consideration exists as follows. Our opportunity to service or repair a vehicle you left with us, financial benefits we receive from others for the service/repair, financial benefits we receive from others to obtain and use the vehicle as a service replacement vehicle, a fee you pay, and/or the rights and obligations of this agreement. So it is absolutely defined in the agreement that there was consideration and what it was.
Counsel, let me
Yes, sir.
ask you about that, if I may.
Sir.
One of the cases you advanced for us to review is the Thayer case, the 11th Circuit case, and I'd like to read 2 sentences from the end of that opinion and ask you about them. And again, quoting Judge Anderson's opinion, whatever label Randy Marion happened to assign to the vehicle here does not control the legal determination of whether the Graves Amendment applies. The substance of the transaction, not the label used, controls. I hear you talking about labels used in the agreements, mutual consideration, et cetera. Doesn't that language from Thayer hurt you?
No. What they were getting to in Thayer, as I believe, was the fact that the defendant had used in answers to interrogatories a loaner or a rental or a lease. And that's when they were saying, regardless of what they call it in their discovery responses, it's the substance of the transaction. And the substance of the transaction, the contract entered into by the parties, defines the terms of their relationship. That's the label I'm getting to. So for what was important to the panel in Romero is that allegedly the lessee had no idea that they were entering into this type of agreement. And my pointing those things out shows that you can't say that here. She literally initialed under the requirements of insurance for rented vehicles. She literally initialed under the criminal penalty for failing to return a rented vehicle. That is my point.
And just so I understand, counsel, her assent to one of those labels, mutual consideration, binds her to that as well as your client. So are we also bound by that? I'm just trying to understand, because consideration, as you also know from Thayer, is an important part of their analysis.
Right, and in Thayer, they found the exact same relationship to have the consideration necessary to fall within the Graves Amendment. But I don't even think counsel is suggesting, and I may be wrong, but I don't think he's suggesting she's not bound by what she signed. And what she signed is an agreement that provides for the consideration of the rental of this car.
So is it fair to say that you're viewing that we don't have to go into too much inspection of Romano and Collins and whether there's a conflict in Thayer? We have this agreement controls, and they have not been successful in undermining it.
Correct. I would actually say that Collins, Romero, and both Thayers, and this case, if you were to affirm, can all be harmonized. I mean, Romero never even analyzed this issue because, I hate to say allegedly like it's accusatory, but because they found it wasn't raised appropriately. It's definitely an issue in this case. It is the issue in this case. It's what we've talked about. It's what it comes down to, is whether there are enough indicia of the relationship here. Now, Judge Lambert and Judge Evander brought up this issue of if someone else came in and wanted to borrow a car for a week. There's nothing of that in the record here. I don't know what type of agreement someone who did that would sign. All I know is that in this case, Ms. Pollard brought her car in for service. She signed this agreement. Again, she doesn't deny signing it. She doesn't deny it's her signature. Nothing like that's ever been brought out. And for 8 days, I believe it was, she drove another vehicle, not her own, so that Bob Steele Chevrolet could service her vehicle. And when her car was fixed or serviced or whatever we want to call it, she brought it back and returned it. Now, in the interim, she got in an accident. But to suggest that this is like a stranger who drove off with a car, it's not that. I would submit to you, I should be careful, I would believe that if someone was test driving a vehicle while they're at Bob Steele Chevrolet, they're not signing an agreement. So I don't know if the Graves Amendment would apply, but I would represent to you that I'm not advocating for that today. This case is simply about what Ms. Pollard signed, what she agreed to, what she had every opportunity to analyze, and what she was bound by. So it's our position that the trial court, I can't tell Judge Jay because I don't have any experience with you. I don't know if you're trying to ask me a question, but I'm talking so fast you're not interrupting, or am I good to keep going?
You're good to keep going.
Okay. I know Judge Evander and Judge Lambert a little bit better, so I can read their cues, but I don't know yours yet.
I like that. My cues are being read here.
Yeah, well,
I'll have to-
you're leaning back, so I don't think
All right,
you're
I'll
going to
lean
ask me a
forward.
question. If you lean forward, you
I'll lean-
might.
All right, I'll lean
All
forward
right.
and not look at you.
And so our point is simply that the trial court was correct in following Collins. The trial court was correct in denying the emergency motion for rehearing because it was untimely. And this court is not bound to stick with the Romero conclusion because the issue in that case is different in this one. What they found was lacking in their decision is not lacking in this case. And therefore, despite the Romero decision, this court can affirm this final judgment in Bob Steele Chevrolet's favor.
Well, plus Cohen and Wozniak aren't on the court anyway, so.
When did the new statute go into effect?
I don't know, and I apologize that I don't know that off the top of my head.
Okay.
I am sure counsel does, but I apologize that I don't, Your Honor.
So, I mean, is it both your suggestions that we may not see too many of these cases because of the new statute?
Yes.
Or at least that's, I won't make Lee.
This would just be a
Mr. Lee
historic-
be bound by your answer, but.
Well, I don't believe, I mean, of course, the statute of limitations has to
right.
run and all that, but I don't believe there are many more of these down the pipeline. But Mr. Lee would know much more than I do because he actually plays in this playground much more than me.
Thank you.
Are there any other questions from the court?
Good?
We're trying to give you back the time from the first one. With that
Jay's
said,
being
I would.
poker face over here now.
With that said, we would request that this court affirm the trial court's final judgment below. I just would bring to the court's attention that we do have an outstanding motion for fees that applies to this, and
Proud of that motion?
am I proud of the motion?
Said it was outstanding.
Oh,
Oh,
but
oh, there's one before us to rule, I get you.
Yes, sir,
You weren't
I'm
just
sorry.
self-aggrandizing there with your motion. All right, I got you.
Yes, sir, thank you.
Okay. I have a great motion for attorney fees pending before the court.
So, Mr. Lee, same question. Do you know when the new statute went into effect?
I believe the new statute went into effect in September of 2021, if I'm not mistaken. There was a period of time where, comments and things of that sort. But yes, it was right around this time where all these were going on. So yeah, I would agree that there's probably not going to be too many of these cases left. And I'm going to try to give you back a lot more time as well. The only thing I wanted
As
to bring
much
up...
time as you want, relatively speaking.
Exactly. The one thing I did want to bring up is going to what Judge Jay talked about from the Thayer decision, the substance of the transaction. What Thayer also said, and I think it's important for the court to look, is that decision, the 11th Circuit made it very clear that that was a very factual decision, meaning that the 11th Circuit actually put a big paragraph right at the end that said, we don't mean this to mean that in every factual situation, this is what happens. And they even talk about situations where a dealership could just be doing a test drive, and I think there's another one in there. So it's very clear that the 11th Circuit was not making this a blanket prohibition across the board. And I think that the Romero court picks up on that as well. Because when we're talking about rents and leases, and I agree, it's about rents and leases, but it's about what the Graves Amendment rents and leases means. And this court said in Romero that those definitions, meaning rents and leases within the Graves Amendment, comport with this court's longstanding ruling that the amount of rent to be paid is an essential element of a lease. It says, statutory interpretation requires a fair reading based on how a reasonable reader would have understood the text. And a reasonable reader, competent in English, would not contemplate that dropping a vehicle off for service and obtaining a complimentary loaner vehicle constitutes a lease or rental situation. And to finish that, it says, a gratuitous bailment, yes, a lease or rental, no. And so what we're saying in this case, at its very core, is that this agreement, whether or not it's called a rental, whether it has rental in the all in it, whether it has consideration in it, it is not bound by those terms. Does not fall within something that the Graves Amendment says is rents or leases.
Your position, this is a gratuitous bailment, or at least there's a fact issue regarding whether it's a gratuitous bailment?
Either one. And the trial court found that there was no genuine dispute of fact, and there was. That should have been something that went forward. So we would ask that the court reverse the summary judgment order. I appreciate your time.
All right, thank you, counsel. Good arguing today so far. Good deal.